My fellow Singaporeans, on the 13th of September, we were given the surprise that the PAP government wants to pass a law known as the Foreign Interference Countermeasures Act, or some people have started calling it FICA. Bear in mind, they only introduced this on the 13th of September, which was about 2 weeks ago. And the intention is to pass it at the next sitting of Parliament on the 4th of October. So, in barely 3 weeks, they want to pass a very draconian piece of legislation. Let me tell you how draconian it is. I have that act in front of me. All right? It is 249 pages with 127 sections. 127 sections. You know, I have spent many days going through this bill, and I am still trying to make sense of how everything flows together. Let me ask you, how many PAP MPs you think will know how to read this piece of legislation and what it actually means? You know, my friends, we are in the midst of the greatest crisis of our times, which is the COVID pandemic, and which the PAP have mishandled so badly. And now they tell us that we are going to have 5,000 cases or more each day. What does that translate to? Even if the figure is only 5,000 cases a day, it means we are going to have more than 1.8 million infections in the next year. You know, you think about that. It means that you are not only likely, you are almost certainly going to get infected by COVID. But they will not spend time or more effort in trying to reduce the number of cases, in trying to protect public health. But in 3 weeks, they want to pass this draconian piece of legislation. Why? It is for their own benefit. And I will explain why. But this certainly is not the way a proper legislature does its work. You know, let's take a look at how a proper legislature such as the House of Commons in England would deal with a very complicated piece of legislation such as this. You first have what is known as a first reading, where the bill is formally introduced. All right? Now, don't be mistaken. At the first reading of the bill is not read in its entirety. It is only formally introduced, maybe with explanatory notes of what the bill is supposed to function as. All right? In this instance, it is to resist or to counteract against foreign influence in our domestic politics. And then, what happens in a proper legislature such as the House of Commons in England is then it goes to the committee stage. It goes to committee, where line by line, section by section, the bill is examined, carefully examined, and debated, and amendments can be made. And once full amendments are made, and that process can take weeks, it can take many months, it is then reintroduced back to the House of Commons, where members can then debate further. And that's not the end of it, because during the members' debate, further amendments can be proposed. And so that is how a proper legislature functions. Not a rush job like what the PAP wants to do to this. In 3 weeks, pass this bill. Now, we have to ask ourselves, is there really a need for such a bill at this point in time? You know, people get excited when they talk about foreign interference. Or at least that is what the PAP wants us to do. Get excited, get nervous about it. And you know, last Sunday, I couldn't believe my eyes. The Straits Times ran many pages in the Sunday Times quoting this expert, that expert, from various institutions talking about the need for this bill. And of course, all that stems from the 2016 presidential elections in America, right? Where it was alleged that there was massive Russian interference in the election, which led to the election of Donald Trump as the 45th president of the United States. But you know what? They went through so many years of exhaustive investigations. And at the end of the day, there was no proof that Russia had actually interfered in the election, in the American elections. And furthermore, Facebook came out with a statement 2 days ago to say that they have never detected any foreign interference in the social media of Singapore. They have detected interference in other countries, in other Asian countries. But even in those countries, they were largely domestic interference, not foreign interference. Of course, you may have many domestic groups agitating, trying to change certain government policies. But to suggest that this bill is needed at this point in time, especially when we are facing the greatest crisis of our times for COVID, is just ludicrous and absurd. But let me tell you very quickly why I find this bill so objectionable. This bill, my friends, gives complete powers to one man. That man is the Minister of Law and Home Affairs. That's Mr. Shanmugam. FICA, I think, is a euphemism. I will call it Shanmugam's Law. It really amounts to that, because all the provisions in this bill gave him absolute powers. Do you know that under this bill, you can be accused of collaboration or cooperation with what is known as a foreign principal? And you know who that foreign principal is? That foreign principal can be a foreigner. Think about it. How many foreigners, you can be speaking to a foreign friend overseas, getting his ideas on what he thinks about a certain issue in Singapore. All right? A social issue. And then you can be accused of collaborating with a foreign principal. And you know what? Under this piece of legislation, Mr. Shanmugam doesn't even have to have concrete evidence against you. He can be acting based on his suspicion. And, how horrible this bill is, I cannot even start to describe. Under Section 18, you can be accused of cooperating, collaborating. I don't know what the words are. I mean, they're so vague and so open-ended. Section 18, the heading is Clandestine Foreign Interference of Target Using Electronic Communications Activity. Now, you can be charged under this act, under this section of the act. And you know what is the penalty under this section? It says, a person who is guilty of an offense under subsection 1 shall be liable on conviction if the person is an individual to a fine not exceeding 100,000 or to imprisonment for a term not exceeding 14 years or to both. All right? These are the sort of penalties we are talking about. And you know what is even more remarkable, my friends, is that under Section 112 of the Act, every offense, it says there, every offense as follows, is arrestable and is non-bailable for the purposes of the Criminal Procedure Code, an offense in Part 2 or Part 3 of this Act. So once you are charged with an offense under Part 2 or Part 3 of this Act, all right, it is a non-bailable offense. It means no one can bail you out. You basically have to remain in remand, in detention, until you are tried and until the verdict is given. That could be 1 year, that could be 2 years, right? You can't get a bailer to free you. Can you now imagine how drastic and draconian this piece of legislation is? To say that it is the modern ISA is not an overstatement. It really is not. And I could not believe my eyes when I read some provisions of this Act. You know, under Section 99, which I think is the most ridiculous section anyone can draft. I do not know if Mr. Shanmugam himself drafted it, all right? Let me just quickly touch on certain parts of Section 99. Section 99 under the heading Rules for Reviewing Tribunal Proceedings. It says, rules may be made by the minister to prescribe the practice and procedure to be followed on or in connection with the hearing or consideration of any proceedings or appeal, including where applicable, the mode and burden of proof and the admissibility of evidence before a reviewing tribunal. So under this Act, a review tribunal is set up for appeals from any decision of the minister. It goes to this review tribunal. But you know what? Under Section 99, the minister gets to write up the practice and procedure of this review tribunal. It even allows him to decide on the mode and the burden of proof and the admissibility of evidence before such a tribunal. Can you believe it? Mr. Shanmugam has become the ultimate law lord in our case, hasn't he? Yeah? He doesn't need to follow the common law. He doesn't need to follow the normal criminal law. He gets to decide on rules of admissibility, on evidence, on procedure, which this review tribunal, which is supposed to review any appeals from his decision. And that's not all, my friends. Let's go to Section 99(2)(b). Because the rules he makes touches on rules enabling or requiring a reviewing tribunal to hear or consider any proceedings or appeal without the person who brought the appeal having been given full particulars of the reasons for any conduct which is a subject of the proceedings or appeal. That is absolutely outrageous and ridiculous. It means that the accused person need not be given full particulars or reasons for why he has been charged for that offense. My friends, a very fundamental requirement of the rule of law, and we pride ourselves on being a society that is governed by the rule of law, right? Not by the rule of man, but by the rule of law, is that every accused person, not even an accused person, you can be a litigant in a civil suit, but the rules of court, the rules of natural justice, the rule of law mandates that you must know the case you have to meet. Here is Mr. Shanmugam writing in these rules, writing in this law to say that, no, we don't even have to tell you the full reasons why you are being charged with this offense. Yeah? Let's go on, because that's not all. Section 99(2)(e) says that the minister, Mr. Shanmugam, can prescribe rules enabling or requiring a reviewing tribunal to take any steps in exercise of their jurisdiction, in the absence of any person, including the person bringing the proceedings or making the appeal and any legal representative of the person. So basically, they can sit and deliberate without the accused person being present in front of them. This is almost like a secret court. They can try you in your absence. You know, I do not know what sort of law Mr. Shanmugam was taught in law school. When I studied law in England in 1985, I was taught about a court called the Star Chamber, which existed for about 300 years between the late 1400s and somewhere in the 1600s. This court, known as the Star Chamber, became so notorious because it was used by the monarchs to deal with political and religious dissidents. It was finally abolished in the 1600s because it was found to have abused its functions. It made up rules of evidence on its own. All right? It passed sentences which were not recognized in law. I thought when I was taught about the Star Chamber, it was only of historical interest. I never knew that one day it would find its reincarnation in our bill, known as the Foreign Interference Countermeasures Act. And let's go on. Look at Section 99(2)(f). Mr. Shanmugam can also write rules enabling or requiring a reviewing tribunal to give a summary of any evidence taken in his absence to the person by whom the proceedings were brought, or as the case may be, to the person who made the appeal. So, they can present evidence against you and say, oh, this is a summary of the evidence against you, without producing in court or in front of this tribunal the person who has made accusations against you. They can say, well, this is a summary of the evidence against you. All right? Probably they don't even have to name the source of this information. That is totally against the rule of law, my friends. Because, as you know, those people who have been in court proceedings will know, one of the fundamental requirements of the rule of law is that the accused must be able to face his accuser and challenge the evidence. In cross-examination, put it to that person, your case, and from there the court draws its conclusions. But it seems to me like all the rules of evidence are being forgone in Mr. Shanmugam's law. And you know what I think is the funniest provision in Section 99? It comes under H, Section 99(2)(h), which says, Mr. Shanmugam again can provide rules providing for the manner in which the interests of a person who has made an appeal under Section 92 are to be represented, such as for the appointment in accordance with the rules by such person as may be determined in accordance with the rules of a person to represent those interests. You know what that means? It means basically you have no right to your own choice of counsel or lawyer. They can decide for you who is to represent you. Yeah? That again is totally against the constitutional principle, even under our constitution, that every person has the right to choose his counsel. So whoever is involved here can make the decision for you and appoint your worst enemy as your counsel, right? Yeah. If I go by section 99(2)H, this is what it says. Really, Mr. Shanmugam, you want the Singapore people, well, your PAP MPs may accept what you want them to do. You want the Singapore people to accept these sort of rubbish provisions? Yeah? To me, illegal provisions made legal only because you have the powers to make it legal in Parliament? I think this is shocking. And I think the whole body of lawyers, the law society, should get involved and speak out against this not only unconstitutional, I will say unlawful piece of legislation. All right? And my friends, you know, reading this bill just makes my blood boil. But I am not finished yet. Because you know what Mr. Shanmugam also wants to do? Mr. Shanmugam, in section 104 of the bill, wants to take away the powers of judicial review by the courts. Now, let me read to you what section 104 says. The heading is limited judicial review. If I can point you to that section, it says limited judicial review. All right? And it says, every determination, order, and other decision of a reviewing tribunal, the minister or the alternate authority mentioned in section 106, made or purportedly made under this act, is final and is not to be challenged, appealed against, reviewed, quashed, or called in question in any court except in regard to any question relating to compliance with any procedural requirement in this act. My friends, I hope you know what judicial review is. I have been involved in a number of judicial review cases recently, notably for Terry Sue and TOC. Judicial review is that area of law where the courts review the lawfulness of any decision-making or actions by a public body. And it has been said that judicial review is one of the most remarkable progress made in the law in the last 100 years. Judicial review is actually a creation of the European courts. And in France, you have huge systems of administrative courts reviewing decisions made by public officials. It need not just be a minister. It can be anyone who has the powers to make decisions which affect the lives of ordinary people. It can be the decisions made by a civil servant, or in Singapore context, made by a permanent secretary, made by anyone in a ministry. Because the rule of law requires that all public officials exercise their powers reasonably and within the law and rationally. Mr. Shanmugam wants to take himself out of this review process, right? And you know what? He wants to take himself out of what the Singapore Court of Appeal said very recently in 2019, yes, 2 years ago, in a case called Nagendran versus the public prosecutor. Nagendran versus the public prosecutor. And even the Singapore courts have said, and I want to read to you what the Singapore Court of Appeal, our highest court, said in the Nagendran case. And the Nagendran case was quite special because it is one of those few cases in which a 5-member panel of the court sat. You know, when you go to the Court of Appeal, usually it is a panel of 3 Court of Appeal judges. When the Court of Appeal panels 5 judges, and in this case including the Chief Justice, Sundaresh Menon, it means that there is an important point of law, of public interest involved. All right? I want to read to you what Chief Justice Sundaresh Menon said in Nagendran. And in paragraph, bear with me for a minute. In paragraph 73 of the judgment, this is what the Court of Appeal said. In particular, any society that prides itself in being governed by the rule of law, as our society must hold steadfastly to the principle that all power has legal limits, and the rule of law demands that the courts should be able to examine the exercise of discretionary power. Powers exercised by the ministers are largely discretionary. And certainly in the case of the Foreign Interference Countermeasures Act, don't you think that many of the decisions Mr. Shanmugam is going to make are discretionary? The courts have always said they have the powers to review. And this power comes from our Constitution, which is the supreme law of our land. Ladies and gentlemen, it comes from Section 93 of our Constitution, which says that the judicial power of Singapore shall be vested in the Supreme Court and in such subordinate courts as may be provided by any written law for the time being in force. There we have it. Here you have Mr. Shanmugam trying to write himself out of judicial review. So, I ask you whether it is warranted that such a draconian bill be rushed through Parliament and passed within 3 weeks. The answer obviously is no. And I say this boldly, my friends. Any member of Parliament who votes in favor of this bill does not deserve your vote at the next general election. Make sure you vote against a person who supports this bill, because a person who supports this bill does not support the rule of law. He does not stand for the Constitution. He does not stand for your civil liberties, your rights. A person who votes for this bill is a person who is voting to trample on your rights. I cannot put it any stronger than that. But I hope you will make your views known to your MPs before this crucial vote. You will tell them how much you object to this bill, and you tell them that there are consequences if they vote for this bill. Thank you very much. Thank you.